Hello everyone and welcome to the second of our video tutorials on lay people. In our first lay people video, we looked at the work of lay magistrates. In today's tutorial, we'll be looking at the work of juries, and juries are the second type of lay people or unqualified persons who are involved in the English legal system. So to begin with then, a jury is a sworn body of people, known as the jurors, who are convened to render an impartial verdict, which means a finding of fact on a question which is officially been submitted to them by a court. And you have probably seen them on the news or in films, a group of 12 people who are sitting, taking notes during a trial, and they're deciding on the issue of guilty or not guilty for the defendant. So juries have been a feature of the English legal system for hundreds of years, but just a little bit of history for you here. Before we had trial by jury, we used to have something called trial by ordeal, and you can see here from 1066. And this was very bizarre. This was where strange procedures were used to test whether suspects were guilty or not. So, for example, in the ordeal of hot metal, molten metal was sometimes poured into a suspected thief's hand, and if the wound healed rapidly and well, it was believed that God found the suspect innocent, and if not, then the suspect was found guilty. And there were other strange ordeals as well. Ordeal by water, where people would be thrown into water, and if they drowned, they were innocent. But if they didn't drown, they were guilty and then faced punishment at that point. But in 1215, the Catholic Church removed its sanction from all forms of ordeal, and instead we got the Magna Carta, which recognised the right for people to be tried by their peers. And the lawful judgment of his peers, or being testing a case through a jury, became the usual method of trying criminal cases. And there's a quote here, famous one from Lord Devlin. He said that juries are the lamp that shows that freedom lives. So he was referring to the fact there that the jury is an integral and indispensable part of the criminal justice system, and the system of trial by judge and jury is of constitutional significance. And the jury is also, through its collective decision-making, an excellent fact finder, and in general, the public trust trial by jury. I've put a link in my PowerPoint to a video that was created by the Ministry of Justice, which is played to juries when they arrive in court to fulfil their civic duty. And it'd be really useful to follow that link and watch that video, because it is a really nice overview of what a juror actually does. So we're going to start by looking at what the role of the jury is in a criminal case. And you could get a 10-mark question on this on exam 1, asking for the role of a jury in a criminal case. And you need quite a bit of detail to get the full marks. So to start off with then, the role of the jury is one of the most important civic duties, and it is expected to be performed unpaid, although the person can claim expenses. So if it costs them £1 to get to court, they can claim that back, but otherwise it's unpaid. And the function of the jury is that they sit as a bench of 12 and decide the issue of guilt or innocence of the defendant. And they are independent. Their decisions cannot be challenged, and that's really important. And those principles have come from Bushell's case and also McKenna. So the judge can't interfere with the jury, the judge can't threaten the jury, tell them that they've got to decide in a particular way. Their decisions cannot be challenged. And the jury is known as master of the facts, whereas the judge is known as master of the law. So what that means is the jury is deciding what the facts are. So they listen to the witnesses, they listen to the evidence, and they work out what they think the situation was. They decide the facts. Whereas the judge in the case is the master of the law, and the judge will guide the jury on any issues, any points of law that he needs to as the case progresses. So during the trial, the jury is going to hear the evidence, they take notes, and they can ask questions, but they have to do that through the judge. So they would write a question on a slip of paper, who gives it to the usher, who then passes that on to the judge. The judge sums up the case and all the evidence to the jury and directs them that they need to decide a verdict. But the jury will go away and decide their verdict in private. And nobody is allowed to be in there when they're making their decisions. It's completely private. And a foreman, so an appointed person of the jury, will lead the discussions. And usually we want a unanimous decision. So hopefully all 12 jurors will come to a unanimous decision on guilt or innocence. But if they can't make a decision, if there's disagreement between them, we can sometimes reduce it to a majority verdict of 11-1 or 10-2 in some situations, but we won't go lower than that. And if the jury can't get to 10-2, it's called a hung jury, where no decision can be made, and that might then lead to a retrial, which is not ideal. So the jury are deciding, based on the evidence presented, whether the defendant's guilty or not guilty. And once they've made that decision, the foreman will deliver the verdict to the judge, and that is the end of the jury's role at that point. They have no role in sentencing. The judge will issue a sentence if they've decided that the defendant is guilty. We've seen from our study of civil process that juries also play a role in civil cases, but this is extremely limited. And in 1998, less than 1% of civil cases had a jury. And we can now only use juries in civil cases involving false imprisonment, malicious prosecution, and fraud. If they are being involved in one of these civil cases, then the role of the jury in that case is to decide upon the liability. So the deciding is, our defendant liable or not liable, and they decide that on a balance of probabilities, which means more likely than not. So that's a lower standard of proof than in a criminal trial, which requires that the jury assure beyond reasonable doubt. In civil cases, the jury can play a role in deciding the amount of damages or compensation to be awarded. So again, that's different from criminal trials where they have no role in a sentence whatsoever. Juries also have a role in coroner's courts, and these are courts where the jury are looking at deaths that have happened in police custody or in prison, or potentially deaths caused by industrial accident. They're also used where deaths occur that affect the general health and safety of the public. So an example of that would be the awful events at Hillsborough. There was a coroner's court held there to help determine the cause of death of the individuals that died at Hillsborough. And in a coroner's court, we have between 7 and 11 jurors. Now, jurors are selected at random from the electoral roll, but there are some requirements that we need to check our jurors have. So to be eligible to be on a jury, you have to be aged 18 to 75 and registered on the electoral register. That means registered to vote. So if you're not registered to vote, you can't be summoned for jury service. And you have to have been resident in the UK, Channel Islands, Isle of Man for at least 5 years since you were 13, and also not disqualified. People who are on bail, people with serious criminal convictions, or the mentally disordered are not able to sit on a jury. Now, the usual expectation is that once you're summoned, you have no real choice. You have to go and sit on that jury. But it is possible for you to apply to the court for a deferral, which means that you're asking the court to put back your service to a later date, or you ask for an excusal, which means you are asking to be excused altogether from jury service. So you need to have a little look at who can ask for deferrals, who can ask for excusals. In terms of how juries are selected then, at each Crown Court there's an official who's responsible for summoning enough jurors from the Central Summoning Bureau. And names are selected at random from the electoral roll for that area, and those summoned must notify the court of any reason or reasons why they should not or cannot attend. And that might be because they've been disqualified for service, in which case they have to let the court know. Everyone else is expected to attend for at least 2 weeks jury service. In terms of jury vetting, it is very minimal in this country. In America, they use a lot of jury vetting, or voir dire. We don't use that over here. And Denning pointed out in the case of Sheffield Crown Court that jury vetting is unconstitutional. In the case of Ford, a judge, the principle here was that a judge had no power to influence the composition of a jury, whether for reasons of race or sex, meaning that if we randomly select an all-white jury, there is no power to say, well, actually, we need to change it because we need some black people on the jury. The judge has no power to do that. Once the jury is in court, they can be challenged before they're sworn in. So a challenge for cause is where a juror is accused of knowing the defendant or maybe a witness or somebody else involved in the trial, and in which case the defence or the prosecution can challenge for cause and ask that juror to step down. A challenge to the array can be made again by the prosecution or the defence, and this time you're challenging the whole jury, not just one juror, on the basis that it's unrepresentative. So even though we are randomly selecting our jurors, it is possible to randomly select a jury that doesn't look particularly representative. So for example, in the Romford jury, out of 12 jurors, 9 happened to be randomly selected from Romford, and 2 of them actually lived on the same street. So that jury was challenged as being unrepresentative. We've already mentioned there's no power for a judge to order a multi-racial. The final challenge here is standby for the Crown. This is a very rare challenge by the prosecution or the judge, and we only use it in cases of national security or terrorism where vetting has been authorised. And where it's used, we need to get the permission of the Attorney General, and this would be that one member of the jury is asked to stand by. They go to the bottom of the list, and we don't use them on that particular case. To come back to the racial challenges here, a judge can't order a jury to be racially representative. We can't challenge it on the grounds of race. So the jury is still not racially representative, and groups such as the Commission for Racial Equality have said that if race is an issue in the trial, let's say there's a case involving racism, then the jury should contain at least 3 ethnic minority individuals, or else it's not representative. The old report also recommended this, but the government has rejected this on the grounds that it would undermine the random principle. So that's something to bear in mind in our next tutorial as well when we look at evaluation of the jury. So in our next video tutorial, we'll be looking at evaluation of lay magistrates and evaluation of juries.